Once you reach it, but before you have a seat, if you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Please be seated. And sir, once you are seated, if I can get you to scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Jordan Cox, Jordan Cox.
Mr. Griffiths, you may inquire.
The court doesn't mind a question from the table instead of lecture because I'm trying to limit next over.
Not a problem.
Officer Cox, who do you work for now?
Boca Raton Police Department.
And how long have you worked for them?
Approximately 4 years.
I want to take you back to October 26th of 2018. Who were you working for back then?
Miramar Police Department.
And what were your duties back on October 26th of 2018?
Road Patrol.
That evening, that early morning rather, where were you working?
Where was I working?
Where? Yeah.
The city of Miramar.
Any sites in particular, any locations in particular?
No, I was on FTO, so I was kind of roaming around the entire city.
Did you have an occasion to be called over to a Miramar General Hospital?
I did.
And what brought you to that location?
The detail officer put over the radio that there was 2 victims that were shot at the hospital.
When you arrived on scene, what did you observe?
I observed the SUV parked underneath the emergency bay with bullet holes all over it, and there's a black male subject sitting on a bench.
Did you know who that black male subject was?
At the time, no.
Did you later identify or learn who he was?
Yes.
Who was that individual?
Courtland Henry.
Did you see Mr. Henry in the courtroom today?
I do.
If you could identify him by some clothing that he's wearing?
That day?
No.
Or just
today.
now? Just now, yeah, based off him and his tattoos.
Okay, so you see him in the courtroom today?
I do.
Where do you think if you could identify him?
He's wearing a red jumpsuit.
There's that record reflect identify Mr. Henry.
Okay, the record shall so reflect. You may proceed.
At any point in time, did you have a conversation with Mr. Henry?
I did.
And what did that conversation consist of?
Upon arrival, I pretty much asked him what had happened, what was going on. Based off, he looked like he was in distress sitting on the bench. So just trying to figure out what was going on.
What was going on? What was going on around you when you first started talking to him?
You had medical personnel coming out of the hospital, trying to extract the victims from the vehicle, get them inside, and apply aid to them.
Were there any other officers present?
Yes.
Do you know how many were present?
I don't recall.
Do you recall where they were? Where they were standing?
The officers?
Yes.
I had my FTO next to me, Officer Luna, and Jessica Amengor. She was standing outside the emergency room.
So it was just you and Officer Detective Luna who were talking to Mr. Henry?
Yes.
How were you dressed? How were the both of you dressed?
Road Patrol uniform, Miramar Police insignia.
If you could just briefly, what was your conversation with Mr. Henry?
I can refer to my report.
Yeah,
That's fine.
Refresh your recollection.
Yes.
Go ahead and take a look.
Yeah, so based off the what I observed with the vehicle and the victims, pretty much asked them what had happened, what was going on, where did this occur, how did this occur, just to get basic general information to provide to the detectives that were going to come on scene.
And did he provide you that information?
Yes.
Did he tell you where approximately this incident, where the 2 individuals in the vehicle had been killed, that occurred?
Yes.
What did you do with that information?
I provided to the detectives that are right on scene.
Approximately how long were you speaking with Mr. Henry?
I don't recall.
Long period of time, short period of time?
Approximately about an hour.
And the entire conversation, where did that take place?
in the outside emergency bay, and then he was either admitted. He was either admitted to a room, or they took him into a room, and we spoke to him in there as well.
And at what point did you, at any point in time, did you leave Mr. Henry?
I did.
When did you leave?
When I had finished talking to him.
Were there any other officers present when you left?
I would say another officer took my role and stayed with him when I left the room, yes.
And do you know when the detectives arrived?
I don't.
At any point in time when you were with Mr. Henry, did you ever advise him that he was in custody or under arrest?
No, I didn't.
Okay, cross-examination.
Good morning.
Good morning.
You proceeded to the Miramar Hospital because of the dispatch.
Yes, sir.
That was dispatched to all units. How many police cars ended up being there?
I don't recall. Good amount?
Fair amount, more than a few.
Yes.
Someone said it was like a whole Miramar Police Department spot because of the duty. Would that be fair? Anybody on duty that night?
I wouldn't say everybody, because there's a whole city to patrol. A good amount of units were there.
If you could give a guess, was it more than 10 policemen there?
I don't recall.
How many do you recall?
I'm sorry?
How many do you recall?
Approximate?
Yeah,
When I arrived on scene, it was just about 3 or 4 units on scene.
3 or 4. By the time you left, how many were there?
Probably 10 to 12.
10 to 12. Okay. Now let me ask you this. When you arrived, you saw the chief's office. It had a couple of people in it? With the chiefs?
Correct.
Okay. And Mr. Henry was out in the car?
Correct.
You know, if a police lady, excuse me, the person in charge of the emergency room had to sit on the bench awaiting the arrival of the police?
I don't recall.
Right. Nobody had extracted the body yet, correct?
Not that I saw, no.
Was there an investigation into the cause of death ongoing?
I don't recall.
Did you investigate the cause of death?
I did not.
You asked Mr. Henry what happened, correct?
Correct.
And he told you what?
That he and his buddies got shot at in Fort Lauderdale. They were leaving a party.
But didn't you say that he advised that an unknown vehicle drove by and fired multiple shots that he was driving? Is that what you reported?
Correct, on the highway.
Yeah, okay. Now, you said he told you where it was, and your report notes that units responded to the area of I-75 and Miramar Parkway, looking for evidence of the shooting. Units were unable to find any casings or shattered glass, correct?
Correct.
And that was, what time was that? Did you direct them to go to the area of the shooting?
I did not.
You know who did?
I do not.
He told you, when he told you the area of the shooting, you noted it here, correct?
When you say that, I'm sorry, repeat?
Your report notes the area of the shooting. Does that come from something you heard from Mr. Henry? Does that come from a compilation of the other reports?
It's what Courtland Henry advised to me.
Okay. Did you pass that on to the detectives or to anybody else?
I did.
You dispatched it over your
No,
radio?
no.
What?
I spoke to the detectives.
Okay. Did you tell anybody else this is where the scene was?
Not that I recall.
Did you go to the scene?
I did.
You did?
I did, yes.
Did you go look for evidence of the shooting
I did.
before the detectives arrived?
After they arrived.
Okay. Did you find anything?
I did not.
Did you report back to the detectives you didn't see anything?
Correct.
Who was with you when you were doing that?
Multiple Miramar police officers.
Okay. The detectives hired you over at the hospital?
Correct.
With them. They were not looking, correct?
Not that I recall.
Thank you very much.
Based on that, any redirect?
No, Your Honor.
All right, state is the witness excused. All right, sir, you missed that now. Thank you very much. While he's doing that, state, you may call your next witness.
Save a call. Toyota. Steven Toyota.
Huh?
Toyota's coming in, you want to talk?
I have, yeah.
Sir, if I could have you come all the way up to the witness stand, please. Once you reach it, but before you have a seat, you can just stop and look at me, please. Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth.
I do.
Please be seated. Sir, once you're seated, if I could just scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Can you please state your full name and spell your full name?
Stephen Toyota, Stephen Toyota.
State you may inquire.
Good morning.
Currently employed.
Capital Dynamics. It's a global investment firm.
And back in, when did you retire from the Miramar Police Department?
February of 2021.
And were you working with the Miramar Police Department back in October of 2018?
I was
In what capacity?
homicide detective.
And on that night, did you receive a call to respond to the Memorial Miramar Hospital?
It was the morning of the 26th.
7 a.m.
October 26th, 2018 morning. Yes.
And what, if anything, was the call that you received?
I believe it was very generic. Couple dead bodies at the hospital being dropped off by a friend. And just so you know, I don't get into great details when they call me out when I'm asleep because most of the time early information is not accurate anyway. So that's all I had is some semblance of what was going on when I headed to the hospital.
And you specifically do that. You don't know too much so that you can get there and form your own
Yeah,
investigation.
exactly.
And let me kind of ask you, at that point in time, what was your role with the Miramar Police Department? I know you were a homicide detective, but were you kind of stepping back a bit because you were getting ready to retire?
Yeah, kind of internally within our team. We know when people are about to retire, and we try not to put them in really important positions in homicide as they get close to retirement for reasons like this.
7 years later, you
Yeah.
have to come back to court.
Yeah, retired, and so. But yeah, I was definitely taking a back seat on a lot of things. I think that my saying was, I don't want to interview the shooter. I don't want to find the gun.
Excellent.
I don't want to interview the shooter. I don't want to find the gun.
So what was your role when you arrived at the hospital that morning?
A team player. I wasn't the lead. Detective Moretti was. So whatever he needed,
And what, if anything, when you arrived? Well, was Detective Moretti already arrived when you arrived?
he was.
What, if anything, did he tell you when you arrived at the hospital?
I don't recall specifically.
Did he ask you at some point to drive someone he came to know as Courtland Henry?
Yes.
What did he ask you to do with Courtland Henry?
We were trying to locate the scene of the crime.
Why were you all trying to locate the scene of the crime?
Evidence, video, hard evidence, video, anything we could. So also, we want to make sure it's in our jurisdiction. That's like an important part. But no, we're just trying to determine where the crime occurred.
At the time when you drove with Courtland Henry, was he a suspect in this case?
No, he's a victim.
You all at that point believed he was a victim of this drive-by shooting?
Yes.
So when Courtland Henry got into your car, what kind of car were you all driving?
It would have been a detective car. I'm not sure if...
An unmarked?
Unmarked, yeah.
Would there be any cage in the back or anything like that?
No.
Do you recall where in the car he sat?
I want to say I believe he was in the front seat.
Next to you?
Yes.
What did Mr. Henry do with you in the vehicle?
He directed me to the location, and it seemed like it wasn't very forthcoming, and went back to the station. He was courteous. Wasn't obviously I don't think he's cooperative in that situation, but
So there was no questioning back and forth between you and him?
no. Well, questioning is where's this location exactly? Yeah, nothing about potential suspect or, the investigative part. We're just trying to determine where it happened, what happened. It's very, very early on in the investigation.
So it was just a turn left, turn right, go straight.
And then this is where it's at. Like, okay.
Was he at any point in time put under arrest with you?
No,
Was he in your custody at that time?
no,
Was he at any point in time not free to leave? He had said, I'm done with this.
no. He's a witness. He can leave whenever he wants. Well, at the time, we believe he was a witness. So
And so at that time, he was just there voluntarily telling you guys and showing you where this crime scene was.
yes.
No further questions, Your Honor.
Okay, cross-examination, go ahead.
Thank you. Was he talking to you before he gave a statement to Bertrand and Moretti?
I don't know the timing of the statement he gave to Bertram Moretti, but if it was after I drove him around, then yeah, he was talking to me.
After?
No, I'm not sure. What was the timeline of his statement?
You had a crime scene, you said. You said you were investigating a crime.
Yes,
You said that on the record. What constituted a crime?
the 2 dead bodies.
Okay, so you formulated an opinion of crime that occurred. So you had 2 dead.
We were working homicide. Yeah,
Yeah, homicide. You were called out to a homicide.
yes,
You had a person who was not dead, Mr. Henry, correct?
correct,
Who was in the vehicle, correct?
correct,
And you're trying to ascertain what happened.
yes.
Do you know whether or not police officers had already looked for the scene based upon what had happened with the guy, when he told another police, the lady at the hospital or another person?
I'm sorry. Can you say that
Do you know
again?
whether or not he, in their encounter with the first police person on the scene, that he gave a location for the shooting that was already investigated?
I don't remember.
You don't remember?
I don't.
You weren't told anything about where it may have happened?
I may have been. I just don't recall.
All right. So what did Moretti tell you? Take him and see if you can find something?
Yeah, he was, even if, and I don't recall specifically, but even if somebody thought they were, where the crime scene was based on what he had told them, we're still going to do a drive-by in person with him.
So you wanted to go back and look to see for the scene,
Try to find the exact location of the scene.
and you drove him there?
Yes.
That was at the direction of Moretti
Uh,
or Bertrand?
it's kind of a gray area at the direction. We work as a team, so yeah, it would have been, Moretti is the lead detective.
You weren't the guy in charge, Moretti was,
Correct.
So you were getting ready to retire.
Oh, that was the plan, yeah.
Yeah. So Moretti said, hey, I want you to take this guy and go see if you can find out where this happened.
Yep, is that a question?
Huh?
Was that a question?
Yeah.
Yeah, yes.
Yeah. Okay, and so Moretti directed him to you.
What do you mean by that? Directed him to me?
How did you get into the police car? You said to him, come on in the car?
I believe it was mutually, it was discussed that he's going to show us the
Wait,
location of the crime.
This guy knows where the shooting happened. Take him and look for it, correct?
Sounds about right, yeah.
Yeah. Well, who was you with, Moretti and Bertrand?
Not sure.
Where was he when you first encountered him?
I met him at the hospital.
Whereabouts in the hospital?
I don't remember.
Did you make any notes of where he was? You don't have that written down, do you?
I do not.
Okay, so you put him in the police car and you drove him somewhere, correct?
Yes.
What conversations did you have with him? Do you recall any of them?
I don't. I'd have to listen to the recording.
You didn't record them?
Actually, I'm not even sure if it was recorded or not.
Okay, you were a homicide detective, correct? You were called out to a homicide, so you passed on to somebody else. You got an eyewitness to a homicide, and you don't recall whether you asked him any questions or not?
I'm sure I did talk to him. I just don't recall. If there was a recording of it, it'd be easier for me to reflect on that, but
I can't tell you exactly what we talked about, other than we're trying to determine the location of the crime.
To try to determine what happened. Did you ask him for his version of what may have happened to cause the murder?
I don't know if I asked him directly, but I'm sure somebody had asked him, and it may have been relayed to me.
We don't have any notes of that?
No,
Okay. Did you say there's recordings of that?
I'm not positive.
Were you wearing a body cam?
No,
Miramar didn't picture him then?
no,
There's no body cams at any of this stuff, correct?
I don't know.
How long after this did you retire?
February 21, so 2.5 years.
All right. How long were you a homicide detective?
18 years.
After driving with Mr. Henry to the scene, to have gone through this, there was no scene. Did you have suspicions about his involvement?
Let's see. No, not as far as a suspect. Obviously, he's involved. He's there with the decedents. So we knew he was involved, but no, I think he was just being uncooperative. It's very common in my career that people aren't cooperative only because they don't want to get involved. So that's kind of the gist that I got from him.
You didn't want to get involved?
Yeah.
And you were trying to get him involved, of course, by asking him what happened, where it was, right? That's what a detective does, correct?
Yeah, I'm trying to determine the location of the crime scene, yeah.
Okay. And you took him back to Moretti and Courtland, right?
I would have brought him back to somebody, yeah. I'm not sure who I saw
The
one.
road where you thought the scene might be, you took him back.
Yes.
You didn't take him home.
No.
You didn't tell him you're free to go, call somebody, we'll let you go now.
Not that I recall.
Okay. Thank you.
State, may redirect.
No, Your Honor.
Okay, Detective, I actually have a question for you.
Sure.
Let's say you drove out to wherever you were going, and right before you got there, Mr. Henry had said to you, hey, you know what? I changed my mind. I don't want to talk to you. I don't want to talk to anyone. I would like to get out of the car right now. What would you have done?
Let him go.
State, based on my question, do you have any additional questions?
No, Your Honor.
Defense, based on my question, do you have any additional questions?
You would have just let him walk out. Do you know what Moretti and Courtland's intentions were?
No. I don't know their intentions. But no, under the circumstances, he used the word cooperating kind of in a gray area, but he was being courteous. He was somewhat cooperating, so he was free to leave at any time. He was free to leave at any time.
You guys, let me see. You got two dead bodies. You're investigating a person who drove them to the hospital. You have a person who drove to the hospital. He's free to walk away. You're not going to complete an investigation? That's what you told me.
Wait, yeah, I tried to complete an investigation, but he's free to walk away. He's not a suspect. He's not detained.
You want to find out what happened, right?
Of course we do, but we get lied to very frequently. So
Don't you keep people there to finish investigating?
no,
Through your investigation?
no, I wish we did, but no.
Recall what your conversations were with Moretti or Bertrand about him?
I do not.
Thank you.
Just, if he had made, if he had been subject to any questioning by you, as an 18-year homicide detective, that you would have noted in your report, correct?
Yes,
So if at any point in time you had engaged in questioning with him or anything beyond just driving into the crime scene, you would have noted that in your report, correct?
yes,
And that was not your role in this case, to question anybody, correct?
it was not.
You were, not to diminish your role, but like road patrol
Yeah.
officer at that point.
No, I was there for support at that point in my career. I was not trying to get in the lead.
No further questions, Your Honor.
How many police besides you and Bertrand and Moretti were
At the hospital?
there? Yeah.
I have no idea.
It was already a crime scene established there by the first people that arrived, correct?
I believe so, yeah.
Yeah, you had a big crime scene tape, everything else where the truck was. You had, what do you call those people who take pictures? Crime scene investigators there and everything?
Yeah.
They were all there. No question about it, correct?
When I showed up, I'm not sure they were all there yet. Because we're all getting called out.
Huh?
We're all getting called out, so
Called out the whole town, right?
I don't know who they called out. I mean,
You were all called, all the detectives were here. You know the crime scene people were there, correct?
I do not know if they were there at the time.
Isn't it the first thing that you do when you have a thing, something like that, is establish a crime scene? And you have a person to take.
You mean a crime scene log?
Huh?
You mean a crime scene log?
Yeah.
Yeah, we normally do that. I don't know.
You know when it was done, correct?
No, I actually don't know for sure if it was or not.
Okay.
He is, Your Honor.
Thank you, Judge.
State called Detective Mark Moretti.
Sir, if I could have you come all the way up here to the witness stand. Once you reach it, but before you have a seat, you can just stop and look at me. Swear to tell the truth, whole truth, nothing but the truth.
I do.
So once you're seated, if I get you to scoot that chair forward as far as it will go, you can adjust that microphone so it's pointed directly around. If you please state your full name and spell your full name.
Mark Moretti, Mark Moretti.
College you may employ.
Thank you, Judge. Detective Moretti, where are you currently employed?
I'm employed with the Office of National Drug Control Policy through one of their initiatives called HIDA. It's a federal agency.
And what is HIDA stand for?
High Intensity Drug Trafficking Area.
And how long have you been with HIDA?
Since January,
Prior to January, where were you employed?
City of Miramar,
In what capacity?
homicide detective.
How long were you a homicide detective in the city of Miramar?
Almost 10 years,
And how long were you with the city of Miramar in total?
22 years.
And prior to your involvement with the city of Miramar, did you have any other law enforcement or military training?
Yes, I was with the Village of Pinecrest Police Department from 1998 until 2003. Prior to that, I was in the Air Force, 1991 till 1998. Then the Coast Guard Reserves from 2003 until 2017. Served as well as listed as well as a commissioned officer.
So, well over 20 years of law enforcement experience at the time of this investigation.
Yes,
And now, on October 26th, 2018, were you still working in your capacity as a homicide detective in the city of Miramar?
yes.
What is the call that you received that night?
I was
When I
requ-
say night, it was dark out, early morning hours.
I was called to respond to Memorial Miramar Hospital reference a double homicide. Two individuals were inside of a vehicle that were apparently victims of a gunshot.
And did you yourself arrive at the hospital?
Yes.
What, if anything, were you told when you arrived at the hospital?
I believe when I got on scene, I made contact with the supervisor, then later got in contact with Detective Bertrand because it was his week to be on call, so he was technically the lead. He called me out because he was soon to retire in less than a year, and he did not want to pick up another case. And so I agreed to come out and help him.
And when you arrived on scene, did anyone kind of brief you as to what was going on?
The on-scene supervisor briefed me. Then once I got with Detective Bertrand, he briefed me on what he had at that point.
And what were you told was going on at that point?
An individual arrived in the entrance to the emergency room. It was a gray Jeep. The gray Jeep was still there. There was two victims. Both died of multiple gunshot wounds. Then they were later transferred to inside the ER. I believe that's where they were officially pronounced deceased, was inside the ER. The vehicle was still there. It was secured so no one can go in or out of it. Nothing could be touched like any other crime scene, because that's all we had at that point. That was technically our crime scene, even though we didn't know where this incident had occurred. We just knew that this vehicle came to ER with 2 dead bodies.
Now, this individual who came to the ER with 2 dead bodies, who was that person?
It was Courtland Henry.
And do you see that person in the courtroom today?
Yes.
Can you identify him by an article of clothing in his location?
Red jumpsuit sitting next to Mr. Haddad.
Does the record reflect the inquiry identification ended by this witness?
The record shall so reflect. You may proceed.
How did you first come into contact with Mr. Henry?
He was in a treatment room. He was laying in a bed, wasn't handcuffed, wasn't under arrest. He, as far as we knew, he was technically a victim and the only surviving witness of a double homicide.
So when you walked in to speak to him, how did you introduce yourself?
It was recorded. I think I just gave my first name or said detective. I had to listen to the recording, but I had a polo shirt, regular slacks on, gun on my side, ID, badge.
You stated he was in the hospital room unrestrained. Was there anyone guarding the door to the room or anything like that?
The best my recollection at this time, I don't think there was anyone guarding the room. I mean, there was a lot of police presence there that day. There was probably half the west side was over there. So
And when I say guarding the room, as far as you were concerned, he was free to leave that hospital.
he was just as witness. We didn't have anything we couldn't detain him. We couldn't compel him to talk. If he didn't want to talk to us, we couldn't compel him. He was just a witness at that point, a victim.
And the judge has already listened to it, has already evidenced that statement. What was his demeanor like during that statement?
It was I would say a cordial conversation. He was upset. His friends were just murdered in front of him. But there was no hostilities, no arguing back and forth, no profanities or anything like that.
At that time in your investigation, was he considered a victim of this crime?
Technically, he was a victim. He was shot at.
And so was your questioning at that point in time not for incriminating information, but more of how did you end up in the hospital with 2 dead bodies in your car?
But the biggest issue we did not know where this crime occurred. When it initially started off, we didn't even think that this even occurred in our city.
Why is that?
We didn't have a crime scene. What we were being told of where this occurred, we received no phone calls of shots being fired. There was no spent casings, no glass on the road. There was no indication that any crime occurred anywhere in Miramar that day.
And is that why, at the conclusion of your statement, Mr. Henry, you asked him if you would be willing to actually direct one of your officers, to where it happened? Because from the location information he had given to you all at that point, it wasn't matching up.
No.
To figure out where it was.
Even in his statement, he says, "I'm not from here. I'm not familiar with there." So we gave him the benefit of the doubt. Like, okay, people get lost all the time. They might think they're on Miramar Parkway, but actually on Pembroke Road or Pines Boulevard. It's understandable. So he said, "You know what? Just ride with Detective Toyota and show him where it happened."
And did he say, "Sure, I'd be happy to do this"?
I don't know his exact words, but he didn't object. He wasn't in handcuffs. And it was an unmarked police unit, not a cage in the back of that car. So
If he had said, "No, I don't want to do that," what would you have done?
there's nothing we could have done.
Throughout your statement with Mr. Henry, did he ever say, "I don't want to speak to you"?
He never invoked his Fifth Amendment rights.
Even outside of invoking his right, did he ever give you any indication that he did not want to speak to you? Did he say, "I don't want to do this right now"? Did he say, "I'm not comfortable"? Did he say, "Can we do this later"?
No, I mean, every question we asked, he answered. Might not have been the most truthful, but he answered every question.
And after he did this drive-by, was that kind of the end of your interaction with him at that point?
At that point, yes, ma'am.
Now, after that drive-by, did you then go speak with Mr. Henry at another point in time?
I'm sorry, can you say that again?
After that initial statement with him at the hospital, did you then speak to Mr. Henry at any other time?
When he was arrested in Houston, we did fly down to Houston to try to speak with him there, but he wouldn't speak with us then. He definitely invoked his right there.
And not because at that point in time, he was a suspect and wasn't for arrest.
Correct.
Nothing further, Your Honor.
Okay, cross-examination, go ahead.
Good morning, sir.
Now, let me see. You said when you got there, you already had a crime scene, correct? At the hospital? Car was secured?
The car was secured.
That means there was evidence tape on it and all that stuff?
I'd have to refer to the crime scene photos, but I believe they did put crime scene tape up around the vehicle. I'd have to look at the photos.
All right. Was crime scene investigators there from your department?
Yes,
They were already starting their work?
I believe so.
What time did you arrive?
About 6 o'clock.
In the morning?
Yes, sir.
And how long Mr. Henry and Monty been there?
I believe he got there, at 4:35?
So that's an hour and a half. How many cops were there?
You would have to look at the crime scene log, but there was a significant amount.
What do you mean by significant?
Well, it
Are
is.
you from Washington right now?
I don't think that many. The only truly way to answer that question is look at the crime scene log to see who was there. I don't want to give you a number and be wrong, but
Let's say it was a significant police presence in the hospital, correct?
yes, sir.
You had two dead bodies, and you had an investigation going on. You had crime scene there, you had the vehicle involved right there, correct?
Yes, sir.
Mr. Henry was sitting down in the hospital?
He was in a room with a hospital bed. The heart rate monitor was on him. Basically, looked like he was receiving treatment.
What kind of treatment?
That's hospital's protocol. You have to ask him why. He was just a victim of a shooting. I guess they wanted to check him out.
Was he shot?
He was shot at.
There was no physical injury that he was there, correct?
No, sir.
Did anybody report any physical injury?
No, sir.
He was in a hospital.
Yes, sir.
Was he handcuffed?
No, sir.
Okay, now, you talked to the other detectives and you found out you don't have a crime scene to keep time where it occurred, correct?
Correct.
And you went to talk to Courtland Henry, correct?
Yes, sir.
And you say this, you say cordially, if I may, and your first words were Henry. Hey, how you doing? What's up, man? How you guys doing? You say, hey, my name is Detective Courtland, and this is Detective Moretti. Let's him talk. We're here to talk to you about what happened, okay? That was said, correct?
Yes, sir.
Now, the police say to him, all right, listen, you need to be straight up and tell us where this happened. Okay? My understanding, you told these officers something, but the evidence doesn't show that it happened, correct?
Who said that?
Courtland,
Okay.
correct?
Correct. I got the statement in front of me.
Third line down, fifth line down, the evidence doesn't show it happened. You gotta be straight up, correct?
Yep, that's fine. Yeah, you're right, sir.
Yeah, the evidence doesn't show that happened. You're confronting him with the fact that he's misrepresented something to the police, correct?
Yeah, but-
You're saying it doesn't add up, correct?
Correct.
You're confronting him, now that's obstruction of justice, isn't it?
No.
Yes, did you testify in the trial that you had enough to arrest him at that time? You testified to Mr. Alstein that at that time you had enough to arrest him. I can find the transcript.
I would like to see the full transcripts on that because I don't remember specifically saying that we had enough to arrest him at that time
Yeah, okay.
at the hospital because we didn't even know if this crime even occurred in the hospital. So for you to come in here and say that, it sounds like you're trying to put words in my mouth again.
Okay, he's giving you false information according to you, right?
He is giving me false
That's a
information.
crime.
It is. It's a misdemeanor.
You've got two dead people, and he's giving you false information. You confront them with the correct?
Sir, I do not want to arrest on a homicide for a misdemeanor charge, and then we got the speedy trial issues.
You want to arrest for a misdemeanor. Okay. You want to arrest for something more important, correct?
Correct.
Yes. And you're telling him he's lying to you, correct?
Correct.
Okay. You're accusing him of committing a crime. And how many policemen were around?
In that room was just Detective Bertrand and I.
How many were out guarding the room, guarding the hospital, meandering around, doing whatever you cops do?
I could not answer that question because I don't know who was where, was walking
Was there
around.
a dozen?
You'd have to look at the crime scene log, sir.
You don't have any video of it, do you?
No, sir. There was video outside the hospital where when the bodies were brought in, but I think that there's no video inside the ER room for HIPAA reasons.
Okay. So after you tell him that, he continues to talk to you, correct?
Correct.
You continue talking about you need to know where the scene was, correct?
Yes.
And you direct him, you asked him to go with Bertrand, correct? Toyota.
Yes.
How did you ask him?
You'd have to refer to the statement.
No, I'm asking you. You tell me how you asked him.
Would he mind showing Detective Toyota where it occurred?
You already know you lied about where it occurred.
Like I said in the direct examination, I said that sometimes people get confused. Miramar Parkway, Pembroke Road. So
Did you say that to him?
no, sir.
That was in your mind. Maybe he was confused.
Correct.
You were having him go with a detective for what?
To point out the location where
You already committed a crime by misrepresenting.
Mhm.
Was he was free to leave?
Well, if you looked into our statement, we even told him, listen, we don't care about the drugs. We don't care about any other crimes. We only care about the dead bodies. I am not concerned about a misdemeanor lying to me.
But that's part of homicide investigation where it happened, correct? If
People-
a person's
but-
lying to you about where it happened, that can impede your investigation.
Sir, every single homicide investigation we had, people lie to us. It is a part of our job day in and day out. People lie to us, and we understand
You
it.
let them all go, correct?
No, sir.
Okay.
But people lie, we understand it, we accept it, and people lie to us for different reasons. You know, we didn't know he lied to us because he was involved in this homicide. We just figured he lied because they were doing something and they didn't want to tell the police about it. That was kind of our understanding. But we didn't feel that this even happened in Miramar.
Still confronted him.
Oh, of course. I mean, what investigator would not confront them when the facts don't add up?
You don't think that.
I'm sorry, sir. I'm sorry.
You confronted him with the fact you thought he was lying, correct?
Correct.
Thank you. I'll let go of that. Thank you, sir.
Based on that, anything you read?
Detective Moretti, when you all are telling him the evidence doesn't show that happened, was that saying, we think you committed this crime, or was it saying, as you said, on direct, we can't find this crime scene, where is this crime scene?
Correct.
And when the defense counsel keeps saying, he lied, he lied, he lied, we all know he lied throughout that statement.
Mhm.
But in your mind at that point in time, was it, this man is committing perjury by lying to me, or was it, as you said before, he doesn't know the city of Miramar, doesn't understand what road this is, and isn't able to properly tell me where this happened?
We were not thinking that he was involved in this crime whatsoever.
And in fact, at the end of that recording, didn't you all even offer to drive him home?
I'd have to refer back to the full statement, but
If that would refresh your recollection. I believe it is the last sentence, what did I say?
I mean, like I said, it was not a confrontational encounter. I don't know if I have the full statement here. Can I see your version? Okay, it says question was actually from Bertrand, and it says Hector offered him a ride home.
And is that something that in your practice you all would oftentimes do if people are not in custody?
We've never given a criminal a ride home, so.
No further questions, Your Honor.
Based on that, you recross.
I got to ask one other question. Based on that, you've never given a criminal a ride home? You ever given a suspect a ride home with build up evidence to make an arrest later when they were a suspect?
If I was concerned that they were a suspect of a homicide, I am by no means going to get into a car with them and drive them somewhere for my safety alone.
So you've never done it?
No,
Let me
sir.
ask you a question. This person that was just considered a victim took gunshot residue from him, correct?
Correct.
That's what you always do to victims?
Well, we were just trying to figure the case out. He wasn't telling us the truth.
The case was you had accused him of something and he took gunshot residue. What other criminal investigation did you do?
We do that all the time. No, DNA would not have been possible. But we do that in almost all cases, just to rule him out.
Rule him out as a suspect. Because he was a suspect at that time. He was
No,
involved.
he was not a suspect at that time. We had no idea, no indication whatsoever. And even then, when we did the GSR, which there's two different types of GSR tests, the first one is just a presumptive test, and it's done after the initial test. And that just tells us if he handled a gun. That first test came back negative, which even corroborated in our mind a little bit more that he was not involved in any of this.
All right. You were doing investigative stuff, right?
Yes.
That's part of your protocol to take GSR?
Oh, we've done it many times with witnesses and stuff on case victims. That's nothing unusual.
What if they refuse?
No, we don't take it. We ask. The crime scene technician asked.
Okay. A crime scene technician went up to him, asked him for gunshot residue
Yes, sir.
test. Was that at your direction?
I did not direct it, no.
Bertrand?
I do not know.
You was in your presence?
I was there when it was done.
You were there?
I was there.
How many other detectives, cops were
I couldn't even answer that question. At least Hector and myself and Detective Bertrand.
So he was in the presence of at least three.
Well, it is outside the scope, but over your objection, go ahead.
There was 3 or 4 policemen with him, asking him to give him, to let them test his hands, correct?
Correct.
And he thinks he's free to leave?
I can't testify to what he was thinking, sir.
What were the conditions of what a normal person would think, surrounded by police? Is he free to leave?
Well, yeah, I'll sustain that one. I think that's the question I have. Any other questions?
No. Thank you, Judge.
Okay, state this witness.
He is, Your Honor.
Thank you, Your Honor.
You may sit down. Real quick, 5-minute restroom break for the court staff. We'll be in recess for 5 minutes.
You will read this for evidence, right?
Huh?
The audio, you will read that to evidence. You don't need to read that for that. Okay. Just before we let him go.
As well as the top of my page 3, State versus Cortland Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins and Mr. Griffiths present for the state. Mr. Haddad and Mr. Nascimento present for Mr. Henry, who likewise is present. So I heard the evidence yesterday in the defense's pending motion to suppress statements of Cortland Henry. State, am I still correct? There's no other additional evidence, witnesses, or testimony you would like to present as to that motion?
Correct.
And defense, there's no additional evidence, witnesses, or testimony you would like to present as to that motion?
We would like to present the testimony of the defendant, Mr. Henry,
Oh.
for the limited purpose of what happened.
Okay, no problem. Mike, can you hear him over there? Or do you want me to do it? Yeah, Mr. Henry, you can stay right there with your lawyers. Just speak loudly, okay? So we want you to hear the answers. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you put your hand down. Please state your full name and spell your full name.
My name is Courtland, Cortlen,
Okay. Sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up and answer yes or no. So this happened.
Yes.
Okay. And then at some point When you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6.
Mm-hmm.
5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving and speaking to you? So you were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
For the text when we talked to me?
And describe to me the room that you were in. Was it were you there by yourself or other people in the room?
It was like a private hospital room. Probably maybe like 4 different officers in the room. And then like they had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
It was one of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave?
No.
What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to you giving your statement to the officer, the detectives, at some point were the handcuffs taken off?
Yes.
Why?
They want me to go and take, they want me to go to a piece.
At the urine set? Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out, one of the officers?
One of the officers, one of the deputies that was standing guard in the room, they walked me out and walked me into a separate bathroom, restroom outside the room.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are 2 detectives that come in, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As loud as you can, sir.
No, I'm not aware.
You stated you were handcuffed. How long were you handcuffed for?
And most of the time I was there. In the room, in the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until they said I could go. Until they said I could leave, so I could.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time I'm going to states B and evidence in states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be in evidence. That's States Exhibit 2, only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyota out to the crime scene? Where you said the crime occurred? you ride with Detective Toyota, who testified yesterday,
Yes.
out to where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to object, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir, you can answer the question.
You did not ride with Detective Toyota?
I didn't ride in the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
All right, based on that, any redirect?
Judge, just briefly on the photo. Mr. Henry, this photo that you were shown of you in the hospital, do you recall pictures being taken of you? Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken off?
Objection, Your Honor, I said he doesn't recall this speaking.
Hold on, over the state's objection. Go ahead, sir, what's your answer to that question?
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After the handcuffs. No further questions.
Based on that, any recross?
No.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friend came to pick me up.
Someone came and picked you up at the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th. 2019.
All right, State, based on my questions, do you have any additional questions?
No.
Defense, based on my questions, do you have any additional questions?
No, Your Honor.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay. So it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress both. I heard, which I think is contained on State's Exhibit 1, for this hearing, there's two statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
He was not Mirandized, as we know. I think the state will stipulate for that. But what the issue is obviously, he was not at the police station. It's an issue of whether he was in a situation where he should have been Mirandized. Whether the interrogation, as it were, constitutes an interrogation, whether or not it was custodial. Now, the defendant, the police had a shooting. We heard the testimony that a car arrived at the hospital with two bodies in it. Mr. Henry was driving the car. Two bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that were there that there was a drive-by shooting, and he explained to them where it happened. We know from what the detectives testified, other police people, personnel, that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from this transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with Bertrand and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bertrand, and this is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding you told these officers something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's implying Moretti said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized, because the rest of the statement is what they're using to formulate the rest of the case. And I would submit to the court that the police had a duty to Mirandize him under that situation. They have a crime, there's no question a crime committed, occurred. They called it crime scene. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detective corroborated there were a bunch of policemen with around him. Was there a duty to Mirandize him? I submit to the court that in this situation, the defendant was, well, quoting from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation. As this Supreme Court, as this court has explained, a person is in custody if a reasonable person placed in the same situation to his or her freedom of action was curtailed to a degree associated with the actual arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, some crime occurred. He is in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the cases state that a hospital room is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives. Any reasonable person, it's a reasonable man's man, as to whether a person will reasonably believe they were in a situation.
I'm sorry. I apologize. Just pause 1 second. This is Martin.
All right, Mr. Yoder, I apologize. That wasn't regarding a medical issue of women taking the call. I apologize. Go ahead.
If I could go to Russ versus State, which the state relied on it so heavily in its motion because it was a hospital situation. The court stated, quite correctly, police are not required to give Miranda to every potential suspect. Miranda warnings only apply in custody investigations, court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogation in certain custodial circumstances inherently coercive. Statements made under these circumstances are inadmissible unless the suspect is specifically warned of Miranda rights until he decides to waive those rights. And then it says for Miranda purposes, custodial question interrogation means question initiated by law enforcement officer after a person has been taken into custody or the court leader, otherwise deprived of his freedom of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive his circumstances, relying on Yarborough in those cases. A person is in custody, quoting from Hunter, a person in custody if a reasonable person in the same position would believe that his or her action, freedom of action, was curtailed to a degree associated with actual arrest. And I quoted that before. And that's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. That he's lying to them and they have to come clean. And then he's not Mirandized. He's surrounded by a bunch of police. He goes to the bathroom. He has police taking him to the bathroom. He's in a room where the police agree he's surrounded by police. They said there's a bunch of police. 4 or 5 sounds reasonable from what the defendant is saying. They're consistent with what Moretti testified to. Is how many police are there. He's in a room. It's a confined place. He's got policemen around him. And he's confronted with evidence that he's lied to the police. Should he have been Mirandized? Absolutely. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Mirandized. I think under the circumstances testified to as to how this occurred, the defendant was entitled to Miranda warnings under all the cases given. Thank you.
State, your response?
Yes, Judge. Starting with Mr. Henry's testimony, he's clearly not being forthright with the court. As Detective Cox, or Officer Cox testified to, when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified he is not handcuffed. In the photograph, he is not handcuffed. Detective Toyota takes him on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that reporting, where they say, like, we're going to make arrangements to take you home. He was not a suspect. As the officers all, excuse me, as the officers all testified, they thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test, as outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there, crime scene was there, they were processing the vehicle, they were processing the deceased, they were processing for evidence, potentially evidence physically located on Mr. Henry as a victim. The fact that the court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any evidence. They're not saying, we found bullet casings, not saying we found GSR. The confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, or you read the transcript, you can see that. Because on page 9 of the transcript, they're like, look, here's a crude drawing. Did you guys get off the ramp here? Did you drive past the Chick-fil-A? They're trying to figure out where this happened. As I think two of the officers joked, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers testified to is that there were officers around, nearby, and there were, because this was a crime scene. There was an active shooter loose based upon what Mr. Henry told police because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles. So of course police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, the court's considering that, as I cite to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing the crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone, the manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who were the victims? Did anybody have a beef with you? Are you posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation. And I believe all 3 witnesses testified, we believe he was a victim at the time of that. It's a reasonable person standard. The fact that he is having, that they're documenting his injuries, that's normal in nearly any crime. A victim of domestic violence is going to have their injuries photographed. A victim of sexual battery is going to be transported to the Sexual Assault Treatment Center for potential examination. And they have the right to refuse, which is what the officers testified to. Had he wanted to refuse, we would have abided by that. There's no evidence, there's no evidence supporting that this was a custodial interrogation or ever transformed into a custodial interrogation. Miranda warnings were never required for this because, as the officers testified to, at the time that they were questioning him, they believed Mr. Henry to be a victim of this. That's all I have, Your Honor.
Thanks, I'll give you the last word. Anything else you want to
But if I may, I have to disagree with the statements. I do think that the beginning portions of the transcript were replete with instances of the detectives confronting Mr. Henry with what they believe evidence of him lying and not telling the true story of what happened here. We see it in the second question. First question is Henry, but the second question is the evidence doesn't show that it happened there. You lied to us. You're not telling us the truth. If you go on to page 3, we see them confront him on the bottom. Here's the hard part. We're having a real hard time trying to understand is that we shut down the entire area. We had officers at the shoulder walking out. They didn't find as much as one shell casing. They go on, but they end with nothing to what you said adds up. You're lying, Mr. Henry. You're not telling us the truth. We think there's more to this. Later on, they go on, we should expect to find evidence here, and they're describing that to him. Right now, there's nothing, okay? I kind of think I know what happened because I got information that something else happened on the east side of the city, but it sounds similar to your thing, but you need to tell us. You need to be straight up with us, okay? Next question. You're doing your friends a disservice. So repeated examples of them telling him at the beginning of the statement, what you said to us is untrue. You are lying to us. We've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now with the lack of evidence to support your story. So clearly, they're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital room. He has testified to this court he did not feel he was free to leave. This court's going to evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement occurs, again, matters not. There are officers. He was not free to leave the hospital room to go to the restroom. I think it's easy to understand that had he stood up and walked out of the hospital, they would have stopped him. He had been there for some time before the statement occurred. They were collecting evidence because there was a crime scene, including evidence, GSR in his hands, taking his clothes, things of that nature. Things that a reasonable person would not understand to be happening to a victim of a crime, but someone who may be a suspect of a crime. And at the very end, Judge, whether the officers have testified they believed him to be a suspect or not matters not, as the case law tells us. In Stansbury v. California, 511 U.S. 318, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not to you. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical emotion or was his right to decide what to do next curtailed by the action of the officers? And we would submit that it is clearly, if you evaluate it just in the vacuum of that room prior to the statement. Thank you, Your Honor.
Okay, listen, although normally the best practice would be for me to give you all a written order on there, I'm just going to work the bench because of the time constraints that we're under here, and we set the trial. We're going to commence the jury selection next Wednesday. So, regarding the defendant's motion to suppress statements of Courtland Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota to be credible. I find witness Mark Moretti to be credible. For the most part, I find witness Courtland Henry to be credible, except maybe as to this handcuff issue, I just don't know. There's no evidence in front of me to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day? Did you have a gun that day? All right, those are questions that are meant to elicit or could elicit an incriminating response. It's clearly interrogation. That's not an issue. Number two, certainly the best practice would be for homicide detectives to just advise the person of his rights. And were they to advise him of his rights, then we don't have to go through this 2-day procedure, and I'm not called upon to make this determination. But for whatever reason, law enforcement doesn't really seem interested in doing that on a lot of these cases, so I have to make this determination. So really, the whole ball game here is whether he's in custody. And I'm familiar with the case law that the state cited. I've reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. And let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside in the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals. Maybe not in the treatment rooms, but if I had any picture or any video of anything anywhere that at any point in time Mr. Henry had handcuffs on, I'd probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurs. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, that they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a car and driving him to the scene that he says where this took place, because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months after the fact. If he had ever asked to leave, I would feel differently about this. If he had ever told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, listen, we don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to the hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So, again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of some Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such. If and when we arrive at the part in the trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one, and number two, the motion in limine is otherwise moved because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's still correct.
Defense, is that correct? Okay.
The way it stands, I don't believe we would.
All right, so.
Should that happen, we can address it.
Okay, well, as far as the motion for relief, just to file your motion, that's granted, and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter a written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send the jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long in time, but I'll take a proffer from them if I need to outside of the presence of the jury before I make a ruling, although I can tell you I have no policies, but as a general rule, credibility of witnesses is always at issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe to have the jury believe their version of the facts of the case, then I would probably be hard-pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all 3 of those orders today. Ms. Wilcox, this one on top is granted, the reasons stated on the record, and then the motion limited underneath is deferred, the reasons stated on the record.
The motion hasn't actually been filed yet, since we just have to file.
Oh, you're going to file it. I'll consider
I'll
it.
file it today, but we won't.
Do they have a
send
copy of it?
anything.
They already have a copy of it?
Yes, they already have a copy.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not today, Your Honor. Thank you.
Defense, is there anything else that you need me to do regarding Mr. Henry today?
Not today. Thank you.
So Mr. Henry's going to keep a couple dates. Number one, next Tuesday, September the 9th at 1:30 p.m. We'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this, and if Mr. Henry's case does resolve, and again to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line with in-custody defendants, and I will use those jurors.
Not bring him here at 5 in the morning.
Yeah, just sign it. We'll give you a blank order. Just fill it out that says I need him here Tuesday, September the 9th at 1:30 p.m. 1:30 p.m. Mr. Henry, Tuesday would be the last day you're dressed like that. If we go forward with the trial on Wednesday, I need you in your trial clothes, okay? Dress for trial on Wednesday. We're going to have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock.
I don't need an order for 1:30, don't open it for lunchtime. They bring it-
However you want to write it up.
Yeah, when it's 1:30, they usually bring them on the afternoon bus.
Yeah,
When
when
they
it's
bring-
like this,
Yeah.
They'll walk over it.
Yeah.
I'll take care of it. When?
Yeah, just,
Thank you. If we're gonna need it.
okay.
Thank you.
Okay, very good. I already sent you preliminary jury instructions. For the benefit, Mr. Haddad might be the only person I haven't done this with. Mr. Nascimento did it some years ago, but I bet he remembers. And Ms. Collins did it far more recently. But on Wednesday, the only thing I'm going to do is march in 5 panels of 50, 50 at a time. I'm going to have the same trial schedule without the case information sitting in each chair. So they're going to be told that I need them from September the 10th through up to and potentially October the 10th, Friday, October the 10th. There's 2 court holidays in there, Tuesday, September the 23rd, and Thursday, October the 2nd. I'm going to talk to each of those jurors regarding their ability to serve only as to the statutory reasons that I can excuse them. Regarding the schedule only, the lawyers won't have to say anything on Wednesday, September the 10th. Once I get 60 people is the maximum that I can seat in here for a jury panel. So if and when we arrive at 60 people that tell me that they can serve, they're going to be numbered 1 through 60. They're going to come back Thursday morning. When you all leave here Wednesday, you will have a copy of my questionnaire that they have filled out. It's going to be numbered 1 through 60 and a seating chart so you know where each of those jurors are going to sit. And then starting Thursday morning, we are only going to address those jurors by their numbers. I have lanyards numbered 1 through 60. Mr. Court Deputy is going to pass them out every morning. He's going to collect them every afternoon when we're done with the jury selection process. So we're not going to refer to anyone's name on the record. State, you'll know the names because you'll have the list. Defense, you'll know the names because you'll have the list. And I know the names, but again, pursuant to the pretrial orders that I've already entered, everyone's continued to be ordered. We're not going to disclose those names to anyone else. If any of the jurors' names are otherwise released to the public in any way, shape, or form, because I've already ordered the clerk not to do that as well, I am going to conduct an investigation and determine where the names are released from. And if I find out that someone has violated any of those pretrial orders that I entered, I will conduct an indirect criminal contempt proceeding immediately. So I would highly hope that everyone will comply with those orders. We're only going to refer to the jurors by number starting Thursday morning. I think that's it. State, anything else you need me to address before we recess until Tuesday at 1:30?
No, Your Honor.
Defense, anything else that you need me to address until Tuesday at 1:30?
No, sir.
Okay, so I'm going to see Mr. Henry next Tuesday, September the 9th at 1:30 p.m. Division, Ms. Wilcox, that concludes Division FT for today?
Yes.
Division FT is going to be in recess until Tuesday, September the 9th at 8:45 a.m. I hope you all have a good rest of your morning. All right, Mr. Court reporting. That is it. Mike, can you hear him over there? Or do you want me to do it? Yeah, Mr. Henry, just you can stay right there with your lawyers. Just speak loudly, okay? So we want you to hear the answers. Raise your right hand for me, please. You swear to tell the truth, whole truth, nothing but the truth?
Yes, sir.
Okay, you put your hand down. Please state your full name and spell your full name.
My name is Courtland, Cortlen.
Okay. Sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up and answer yes or no, so this to happen.
Yes.
Okay. And then at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6.
Minimum?
5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving and speaking to you? So you were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
The text when we talked to
And Describe to me the room that you were in. Was it were you there by yourself with other people in the room?
It was like a private hospital room. Probably maybe like 4 different officers in the room, and then like they had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes,
Do you recall who placed you in handcuffs?
it was one of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes, one of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes,
And at any time were there any officers in the doorway?
yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave?
No.
What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They wouldn't let me go.
Prior to you giving your statement to the officers, the detectives, at some point were the handcuffs taken off?
Yes.
Why?
They want me to go and take, they want me to go to
The urine set?
Yes.
Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out, one of the
One
officers?
of the officers, one of the deputies that was standing guard in the room, they walked me out and walked me into a separate bathroom, restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are 2 detectives that come in, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As loud as you can, sir.
No, I'm not aware.
You stated you were handcuffed. How long were you handcuffed for?
And then most of the time I was there. And the room was in the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until they said I could go. Until they said I could leave, so I could.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time I move states B into evidence in states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be in evidence. That's States Exhibit 2, only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyota out to the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday,
Yes.
out to where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to object, it's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota.
I didn't ride in the front seat.
You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home?
No.
And they did not give you, law enforcement did not give you a ride home?
No.
No further questions.
All right, based on that, any redirect?
Judge, just briefly on the photo.
Yeah, just go for it.
Mr. Henry, this photo that you were shown of you in the hospital, do you recall pictures being taken of you?
That moment.
Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken off?
Objection, Your Honor, I said he doesn't recall this was taken.
Hold on. Over the state's objection. Go ahead, sir. What's your answer to that question?
That was after
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross?
No, Your Honor.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friend came pick me up.
Someone came and picked you up at the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th of 2019.
All right, State, based on my questions, do you have any additional questions?
No, Your Honor.
Defense, based on my questions, do you have any additional questions?
No, Your Honor.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Well, at this time, Your Honor, the state would move what has been already provided to Your Honor.
He's already got it. That's labeled up there.
All right, let me go back on the record. This is State versus Courtland Henry, 19-1871 CF10A and 23-10643 CF10A. I continue to have Ms. Collins, Mr. Griffin's present for the state. Mr. Haddad present for Mr. Henry, who continues to be present. State, yes.
As a formality, the state would move at this point what has been provided to Your Honor previously in reference to State's Exhibit 1. It's the two clips that Your Honor already talked about for audio files that the state already discussed, that Your Honor reviewed by stipulation of the parties.
Defense, any objection? All right, without objection, Ms. Wilcox, we'll call this State's A for identification. Is going to be in evidence only for the purposes of this hearing. That's State's Exhibit 1.
I had talked to the state because I had got received the other day my voice kind of stuff about doing arguments tomorrow. I'd rather.
We have no objection to that. So.
That's fine.
And I may put them on,
That's fine.
but I can't talk on my good tomorrow.
State, you have no other evidence or witnesses or testimony you want to present today.
No, Your Honor, just argument.
And Mr. Haddad, whatever evidence, witnesses, or testimony you want to present,
And
you want me to do that tomorrow? All right, that's no problem.
I also, with the state motion, between stuff.
Oh.
We said, you know, like, I don't know what to call it.
We filed the state's motion for relief from the trial order.
Yeah, to file your motion in limine.
Correct, but I think we agreed that that's moved because he doesn't intend to call.
The two witnesses. All right, I'll handle that when we do the arguments tomorrow.
Just so Your Honor knew it wasn't something that was
Understood.
heavily litigated.
Yeah, that's fine. So the only thing I'm going to press pause on the all pending motions, and again, we're going to resume tomorrow at 9 o'clock. That's the defense motion to suppress. I'll give you a ruling on the state's unopposed motion for relief from the trial order, as well as the state's motion in limine. But I'm going to let each side continue to present whatever evidence, witnesses, or testimony they'd like to do before that. So I'm going to pause on the evidentiary portion today. I do want to have a quick conversation with Mr. Henry. I'm going to put him under oath, talk to him about the charges, make sure he understands the maximum possible penalties, make sure he understands the state offer.
I think that's something else the defense wants to speak to him about tonight.
Well, I'm going to put it on the record right now, but he doesn't have to tell me what his answer is now. But I just want to make sure he has all the info. And what I'll tell you all, I'll be back here tomorrow, and then, you know, I'm going to tell Mr. Henry this as well, but for his benefit now, if he wants to resolve the cases by way of a negotiated plea, that's fine with me. And if he doesn't want to, that's fine with me too. But the one thing that I am going to change, if you need me to, I can put him on maybe Tuesday afternoon, the 9th. I'd rather just not do it. I'd rather know yes or no the day before, because there's a significant, number one, I don't want him to feel any pressure. But number two, I got 250 citizens coming in here Wednesday morning, and there's
Tuesday
just,
afternoon is fine, Your Honor.
yeah, if need be.
I have a hearing at 3:30.
It's fee hearings, you know.
Yeah, so I don't really have to say.
But I'm going to be here,
Oh,
right?
yeah.
Okay. All right, so Mr. Henry, listen, I'm going to put you under oath, and ask you some questions, okay? It's only going to be as it relates to the state's offer, and it's only as to make sure that you understand the state's offer and you understand the charges that you're facing here. We're not going to talk about anything else. So just listen to my questions and answer the questions, okay? Raise your right hand. You swear to tell the truth, whole truth, nothing but the truth. Okay, you can put your hand down. Please state your full name. How old are you?
26 years old.
How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? All right. How are you feeling this morning? Your head is clear? You understand what's going on? All right, so Mr. Henry, listen, you got two cases. I'm going to go one at a time. In case number 19-1871 CF10A, right now, you're charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital felonies, which means it's a mandatory life sentence. If the jury convicts you of count 1 or count 2 as charged, that's life in Florida State Prison. I have no discretion. Count 3 and count 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty for each of those is 30 years in Florida State Prison. Okay? In your other case, which is case number 23-10643 CF10A, you're charged as follows. Count 1 is tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. All right? As the maximum penalty. Count 2 is directing the activities of a criminal gang. That's a first degree felony punishable by life. So the maximum penalty there is also life in Florida State Prison. Count 5 is conspiracy to commit tampering, and again, as it's charged, that is also a life felony. The maximum penalty is life in Florida State Prison. And lastly, count 7 is unlawful use of a two-way communication device. As that's charged, it's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So right now, as to all the charges that you're facing, the maximum possible penalties are as follows. It's life in Florida State Prison, followed by 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 75 years in Florida State Prison. Do you understand the charges and the maximum possible penalties involved? Okay. So, Mr. Henry, the state is telling me that they're extending an offer to you, and the offer is as follows. In case number 19-1871 CF10A, they're going to null pros or drop counts 1 and 2, both first-degree murder charges. Okay, and in exchange for that, as to counts 3 and 4, in that case, the accessory after the fact to murder in the first degree, you're going to plead no contest to both of those. And as to the 4 counts in case number 23-10643 CF10A, you're going to plead no contest to all 4 of those counts. And in exchange for all of that, the state is offering that I would adjudicate you guilty and sentence you to the bottom of your sentencing guidelines, which is 195.45 months, about 16, it's a shade over 16 years and 3 months. 16 years and 3 months. All of those sentences will run concurrently, that is at the same time with each other. I would give you credit for all the time that you have served, understanding that you have a lot less credit time on the 23 case because it's a newer case. So that is what would be controlling. Whatever credit time you have on the 23 case, you could subtract that from the 100
I think
and...
he actually has more time on the 23 case than the 19 because he's out of custody.
Oh, okay. Well, whichever case you have more time, less time in custody, that's what would happen. And you get the credit for all the time that you've served. And again, that sentence would be 16 years, a shade over 16 years, 3 months in Florida State Prison. I would have to order restitution. The state would tell me the amount of that restitution. That restitution would be joint and several with any of your other co-defendants. If any of the other co-defendants were convicted at trial or entered pleas. In other words, the restitution only has to be paid once, but each person is responsible for 100% of it. All right, but as soon as it's paid, it's paid. I would have to impose mandatory court costs in each case, and I would have to impose a mandatory cost of prosecution in each case, which is $100. So, Mr. Henry, do you understand the offer that the state is making to you? Okay, the 16 years, 3 months, and a shade more. So I'm going to pause on it at this point, Mr. Henry. It's going to give you some time, whether that be tonight or also over the weekend to talk to your lawyers about it, make sure they answer all your questions, talk to your family about it so you can make a decision as to what you want to do. Now, let me explain this to you, sir. I can't make the state make you an offer, and I can't make you accept any offer. I'm just the referee, okay? This is a business decision between you, your lawyers, and the state. And if you want to accept it and resolve both cases that way, that's fine with me. And if you want to have a trial in both cases, that's fine with me too. It doesn't matter to me in any way, shape, or form. But whether it be tomorrow, when I see you tomorrow, and then Ms. Wilcox, she already has tomorrow at 9 o'clock, that'll remain on. But I'll put them on both cases as well next Tuesday, which is September the 9th. Let's just call it 1:30 in the afternoon. September the 9th at 1:30 in the afternoon. We'll call it trial status in both cases. That's when we're gonna have to finish this conversation, Mr. Henry, and you're gonna have to tell me that either that you understand the offer that the state's making, that your lawyers have answered your questions about it, and then you're gonna have to tell me what your decision is, whether you want to accept the offer or whether you want to reject the offer. Mr. Henry, the one additional thing that I like to talk to people who are sitting in this situation that you're sitting in right now, and I have this conversation is as follows. The reason that I'm doing this is because I want the record to be clear what the state's offer was, and the record to be clear that you understood it and that you had enough time to talk to your lawyers about it. You had enough time to talk to your family about it. You weren't under any pressure to make a decision, whatever you thought was in your best interest. Because it goes kind of like this. And I'm sure your lawyers could speak to it better than I can. If you accept the state's offer, that's fine. And again, if you don't accept it, that's fine too. But if you don't accept it, and one of these trials doesn't go your way, and you end up with life in Florida State Prison, which is a mandatory sentence on a lot of these counts, usually people in that situation, then they'll file what's called a motion for post-conviction relief, and they'll say, hey, Judge, my lawyer never told me. I didn't know that I could resolve all this for 16 years and 3 months, and if they would have told me that, I would have done it. And now I'm sitting here with a life sentence. So that's the reason I'm having this conversation now, so the record's going to be crystal clear on that issue. If it doesn't go your way, that argument's not going to be available to you to come back and say, hey, my lawyers didn't tell me about this, or I didn't know about this, so that's why I'm talking to you about it now. So, Mr. Henry, do you have any questions for me about the maximum possible penalties involved or what the state's offer is to you as we're talking about it right now? Okay. All right, so I'm going to pause on that part of the conversation, and we'll finish that other part of the conversation either tomorrow or next Tuesday afternoon. I'm going to leave you on for tomorrow, all pending motions, which is September the 5th at 9 o'clock. I have one other matter that I need to handle prior to that with Mr. Gibson and Mr. Percio. I don't imagine that's going to take too long. And then I'll be right with you all tomorrow. And then, Ms. Wilcox, we're going to put both of Mr. Henry's cases on Tuesday, September the 9th, 1:30 p.m. We'll call that trial status, and he remains set for trial in both cases on Wednesday, September the 10th at 9 o'clock, understanding that if we go forward with the trial, it's going to be on the murder case, the 19-1871 CF-10A. State, is there anything else that you need me to do regarding Mr. Henry today?
There you are.
Mr. Haddad, anything else you need me to do regarding Mr. Henry today? Okay. All right, so we'll press pause at that point, Mr. Henry. I'll see you tomorrow at 9 o'clock, which is Friday, September the 5th. Ms. Wilcox, does that otherwise conclude the FT docket for today?
Yeah.
Okay. So the FT is otherwise going to be in recess until tomorrow, which is Friday, September 5th at 8:45 a.m. I hope you all have a good rest of your afternoon. All right, Mr. Court Reporter. That is it. Mr. Henry, I'm going to put you under oath, and I'm going to ask you some questions. If I ask you something you don't understand, please let me know. I'll try to ask you a better question, okay? As loud as you can so the court reporter can get down all the answers, okay? Raise your right hand for me. You swear to tell the truth, whole truth, nothing but the truth? You can put your hand down. Please state your full name. How old are you? How far did you go in school? Do you read and understand the English language? Are you presently under the influence of any drugs, medication, or alcohol? Have you ever been treated for a mental illness? Are they giving you any medication in the jail right now? How are you feeling this afternoon? Your head is clear?
You understand what's going on this afternoon? You understand you're resolving 2 pending felony cases this afternoon? Right. Mr. Haddad or Mr. Nascimento, have you seen or heard Mr. Henry say or do anything which would call into question in your mind whether he understands what's going on?
Nothing at all. No, Your Honor.
All right, so Mr. Henry, it's 2 cases, sir. I'm going to go one at a time. In case number 19-1871 CF10A, this is before the agreement you made with the state, before the deal you made with the state. You were charged as follows. Counts 1 and 2 is murder in the first degree with a firearm. Those are capital offenses. The maximum and mandatory penalty is life in Florida State Prison. Counts 3 and 4 are accessory after the fact to murder in the first degree. Those are each first degree felonies. The maximum penalty is 30 years in Florida State Prison. In case number 23-10643 CF10A, you're charged at count 1, tampering with a witness in a capital felony. That is punishable by life in Florida State Prison. Count 2, directing the activities of a criminal gang. That's a first degree felony. Again, punishable up to life in Florida State Prison. Count 5 is conspiracy to commit tampering. Again, as it relates to a first degree murder charge, that is punishable by a maximum penalty of life in Florida State Prison. At count 7, unlawful use of a two-way communication device. As charged, that's a second degree felony. The maximum penalty is 15 years in Florida State Prison. So, sir, again, before the agreement you made with the state, before the deal you made with the state, your maximum exposure here was life in Florida State Prison, followed by 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 75 years in Florida State Prison. Sir, do you understand all the pending charges and the maximum possible penalties involved? And it's my understanding that you want to resolve both cases today. Is that correct?
Yes.
And that resolution is an agreement you've reached with the state, the terms of which are as follows. Number 1, in the 19 case, you're going to plead no contest to both counts of accessory after the fact. In the 23 case, you're going to plead no contest to all 4 counts as charged. In exchange for that, the state is going to null process, that is, drop the 2 first degree murder counts. All right, I'm going to adjudicate you guilty. Yes, sir.
I'm sorry, he's not pleading guilty to count 2 of the newer case, the criminal.
What's happening with that?
That would be no problem.
So he's only going to plead to the tampering with a witness in a capital felony, conspiracy to commit tampering, and unlawful use of a two-way communication device?
Just the tampering and the unlawful use.
Just count 1 and count 7.
Correct.
State, you're going to null process count 2 and count 5,
Correct, Your Honor.
as it relates only to Mr. Henry.
Correct.
Okay. So, Mr. Henry, what it's going to be is 2 counts of accessory after the fact, tampering with a witness in a capital felony, and unlawful use of a two-way communication device. In exchange for that, I'm going to adjudicate you guilty on the 2 accessory counts as well as the tampering count. I'm going to sentence you to 10 years in Florida State Prison. That will be followed by 6 years of reporting probation. In the unlawful use of a two-way communication device, that's a second degree felony. The maximum exposure.
It's a third degree, Your Honor.
It's the second as charged, I believe. It's a third except as it relates to a capital case, but I'm happy to
Our
look it up.
state has it as a third, that's what we discussed, so.
Well, what did you want the negotiated sentence to be for that?
That was just going to be the maximum time served.
5 years? Is that what you want me to do?
Correct, Your Honor.
Okay. All right, so, sir, as to that count, it's going to be an adjudication of 5 years in Florida State Prison. So the 2 accessory counts as well as the tampering count, those come with 6 years of reporting probation after the Department of Corrections sentence. I'll give you credit for all the time that you've served in both cases. All of those counts will run concurrently. All those sentences will run concurrently. All counts in all cases, that is at the same time with each other. I'm going to have to impose mandatory court costs